Our last case for today is Galvan versus Poon. Good afternoon, council. This is a 15-minute mini oral argument on the application. You have 2 minutes of a free fire zone, which you may waive, and you may reserve time for rebuttal, but we ask that you keep track of your own time.
I would like to reserve some time for rebuttal. Can you tell me what a free fire zone is?
Where you have a period of time at the beginning where we will not interrupt you.
Oh,
2 minutes. You want to waive it?
I'll waive that.
All right. And how many minutes?
I would like 5 minutes
5 minutes.
in rebuttal, if you would. And it's 1:31.
Good luck.
Thank you.
Yes.
Okay. So my name is Joseph Lloyd. I'm appearing in this case on behalf of the Poon family, the defendants, but I am also here to address the concerns of 3,500 members of the real property section who filed an amicus brief, and 36,000 realtors who, through the Michigan Association of Realtors, have also filed an amicus brief, both of whom agree with our position that the Court of Appeals decision should be reversed. The issue that's presented on appeal is one of statutory interpretation. The question that you've posed and we're trying to address is whether a covenant in a warranty deed, it's a statutory deed under the statute 565-151, which states, the statute states that the premises are free from all encumbrances. The question is, does that include a covenant that the structure conforms to currently applicable building codes? The issue is not, as the Court of Appeals noted, whether the defendants knew or were liable for the violation. It's what the statute, what the word in the statute means. The issue is also not about the issues that were decided by the jury and which have not been appealed. This was a long trial a while ago, a lot of counts. There were counts of fraud, misrepresentation, fraudulent concealment, silent fraud, rescission of the purchase agreement, loss of consortium. And there was one count that was breach of warranty. That's the only one that's here, but there was a trial, there was a verdict that's not being appealed. The statute that we're interpreting was created about 140 years ago. And I think the parties are in agreement, and also the amici are in agreement, that there has been no case in Michigan, and I think the Mar argued that there's been no case precisely in any other jurisdiction that's precisely on point, dealing with building code violations in the context of an encumbrance. The statute, when it was adopted, was a conveyancing statute. If you've ever had the mixed pleasure of reading old deeds and sort of wading through the language, what this statute did in 1881, it condensed down into 2 words, conveys and warrants, what used to take 2 paragraphs. And we fight over what we fight over. And that's the way it's been interpreted ever since then. What the legislature did not do in that statute, well, first they titled it, it was a statute to regulate the form of deeds. If we're interpreting the statute, we have to look at the legislative intent. I think that means we look at what they intended in 1881, and the fact that it was to regulate the form of deeds and not having anything to do with the structures on the property seems to be a decision. And the fact that nobody's tried to apply it that way in the last 140 years also reflects a decision. What the Court of Appeals did was took a warranty of title and decided to treat it as a warranty of fitness. And that's the problem. I'm going to try to, I have 3 points really that I'm going to try to squeeze into my...
Let me ask you a question. Sure. If the city had sued defendants to bring the condominium into compliance before the conveyance, would that constitute an encumbrance?
If the city had sued, I think it becomes an encumbrance, certainly when it's a judgment, but if they had sued, it would also have been disclosed and everything would have been on the table through the Seller's Disclosure Act. An encumbrance,
I'm trying to get to whether a building code violation can ever constitute an encumbrance.
well, yeah, absolutely it can't. Well, encumbrance, no, wrong. I mean, what I'm saying is there is a warranty that deals with some building code violations. In the case of Leaks v. Slavic, you know, in a new structure, you have a warranty of the fitness of purpose. And there's also, you know, a newly built home, the builder has liability for it. But those cases, I mean, the case law has been limited to the new structure. I think a building code violation is never an encumbrance. It's just, let me go back and look at the 1880s. There was a case. I mean, the Court of Appeals identified the case, they cited it, but I think they misinterpreted. It's an 1879 case, Post v. Campo, and they talked about what was an encumbrance. And they specifically said, they went through some talk, and then they said, in short, talking about an encumbrance, every right to or interest in land to the diminution in value of the land, but consistent with the passage of the fee. So there were 3 clauses there, but I think the last 2 modify the first. It's not interest in land or diminution in value or dealing with the fee. What you have to do first, you have to have an interest in land before they reach the diminution in value. And when we read the Court of Appeals opinion, that's what they talked about. You know, it didn't have any value, they lost, it couldn't be marketed or sold. They're talking, well, you know, it could have been. I mean, somebody would have been buying a project to fix up. But the title was good. Nobody else was claiming an interest in the property. The interest in land is the thing that they ignored, and an interest in land doesn't go along with it doesn't become an encumbrance. The fact that there's a violation doesn't give anyone an interest in the property for purposes of conveyance or title. The key word is interest. Let's see, the second point I would like to make is that this is a big deal. I mean, the fact that I've got, you know, 40,000 realtors and lawyers whose trade organizations are weighing in on this now tells me it's a big deal. And it's going to change. If this case were to flower and stand, it would change a lot. The questions, the Court of Appeals opinion raised more issues than it settled. So how would you deal with this in the context of an as-is clause? I mean, is there a warranty or is it as-is? The Poons had both. I mean, they gave a warranty deed and they had an as-is clause, but is that the way it is, so that an as-is clause means nothing in the face of an unknown violation? I mean, that's, you know, that'll change a lot of people's perceptions, buyers, sellers, realtors, lawyers. You know, what do I do to protect myself? I know some lawyers, on the basis of this opinion, are already starting to think about rewriting the deeds they draft and their sales agreements, so as not to come into what they don't know will happen or won't happen. There's a lot of standard documents. I tried to figure out how many sales they do every year in Michigan, with no luck. Google wasn't helpful. But there's a lot of activity that now is more precarious. And then there's the question of, Michigan also has a lot of older housing stock, you know, where the house that was built 60 years ago, complying with current codes, and you know, you don't know what's behind the wall till you open up the wall. I mean, somebody wants to come in and redo classic Victorian somewhere, and they find, you know, that after they've had an inspection, after they've had it valued, after they've looked and kicked the tires and done everything they can do, they find some code violation behind the wall, and now, no matter what the parties negotiated, the seller's on the hook. And he may not have known about it. You know, that's not the issue. I'm not going to wade into that, but the Court of Appeals said that's not the issue they're looking at. So if we do this case by case, there's the risk of litigation. That's a pretty subjective thing on which to base all of a sudden it's an encumbrance. Or the question of diminution of value, well, how much? I mean, again, the Court of Appeals didn't do this. And I would pose to this court that it would be a lot better if the legislature would have worked that sort of thing out, because there'd be hearings and history and lobbyists and people would weigh in. We'd see it coming. We'd know how to deal with it. This just dropped out of the skies, and people are having to react to it. So in my world, it caused a ruckus. So that's all I'll say. But it doesn't help the public. It isn't a good decision if it causes more problems than it solves. The final thing, I mean, not the final thing, I guess what I would say is remember, there was a trial on this. Michigan has a body of case law and statutes and ordinances that deal with exactly this kind of thing. They tell me, the buyers and sellers, what they have to look at, what they have to be careful of. They help you weigh the risks you're looking at and decide how we've balanced it. That's what the sales agreement is all about. And we don't want to upend that without some thought, some input. And it's like, a Monet painting. If you're painting it a dot at a time, it takes a long time to know what it looks like. And while that's happening, there's a lot of people that would be befuddled and sort of concerned. Boon for lawyers, not a boon, I guess, it's a lot of work for lawyers and a lot of anxiety and risk for homeowners. The third point, I think that was my second point.
I don't mean to interrupt you. Did you say you wanted to save some time? Or
Yes, please.
You're down at 3:45. You control it. You can use it now or save it.
I'm going to save it.
Thank you.
Who knows what will come up? I'll be back in a minute, or back in 15.
Save it for rebuttal, though.
Yeah.
Good afternoon, Your Honors. I'm Jennifer Alberts, and I represent the appellee in this case, Reyes Galvan. The appellants and the amici in this case have repeatedly emphasized throughout the case that Michigan's warranty against encumbrances initially stems from the common law. But the position they advocate is not actually consonant with the way that the common law has been developed across this country in various states. That is, appellants' extremely narrow interpretation of the word encumbrance to relate solely to the status of title to a property and not the condition, never the condition of any buildings on the property, is not consistent with the law of other states. The Court of Appeals interpretation of the word encumbrance is thus not as much of an anomaly as the appellants claim. I'd like to point out that there are other covenants included within a warranty deed that directly go to the legal ownership of the property. There's a covenant that one actually owns the property. There's a covenant that one has the legal right to transfer the property. The covenant against encumbrances relates not specifically to another person claiming full ownership of their property, but essentially to monetary claims against a property, such as a lien, a mortgage, those types of charges against a property. Now, this court has itself defined an encumbrance to include any condition which may work a forfeiture of the estate. To this day, the condominium association is seeking to foreclose on the plaintiff's home. There is a lien, there is a foreclosure, and the conditions the property were conveyed with may and likely will, in fact, work a forfeiture of the estate. Plaintiff thus asks this court to hold that the conditions existing at the time of the sale in this case were an encumbrance within the meaning of the warranty against encumbrances.
Do you think I'm misreading the case law when I suggested that it seems the great weight of authority would indicate that latent building code violations do not constitute an encumbrance?
I believe that that's a little bit of a simplification, Your Honor, but I wouldn't entirely dispute that. So the cases in other states, there are some states that do not have any holding with respect to building code violations. They deal
Okay.
with zoning code ordinances.
So they don't help us?
And then there are other states that deal with building code violations and differentiate them from zoning ordinances. But those building code cases, pretty much unanimously, they frequently focus on the specific facts of the case. So in Domer v. Sleeper, which is one of the cases that the appellant cited, for example, the court heavily emphasized, under the facts of this case, where the sellers had no knowledge of the violation, we would not consider it an encumbrance. And in this case, we believe that the seller actually did have knowledge, essentially, of the problem, because the seller was fully aware, admitted in testimony, and signed a form that there had been modifications to
But
the
isn't that a
unit.
different cause of action? I mean, aren't there causes of action for what could be fraud or dishonesty in filling out paperwork?
There are, Your Honor, but that doesn't necessarily mean that it doesn't also constitute a breach of warranty cause of action. One point that I would really like to emphasize, though, is that in the Court of Appeals and in this court, we raised two possible encumbrances. One was the building code violation, and that's the one that the Court of Appeals did latch onto and conclude in their opinion. But we also mentioned the issue of condominium-specific deed restrictions. Basically, the overwhelming authority in other states may distinguish between zoning ordinances and building code violations, but it also, these states hold that, for example, a violation of a private deed restriction that exists at the time of sale would constitute an encumbrance. The facts of this case are very unique, and I wasn't able to find any cases with a similar situation because it's a condominium at issue, and the condominium bylaws were also violated. And in addition to that, there was a specific form that the sellers had signed that said, we assume liability, we recognize that we're responsible for any repairs to modifications to this unit. And normally, under the bylaws, that would be the responsibility of the association. So my client wouldn't have been responsible at all. But the sellers actively assumed responsibility for the repairs of these walls. And then that form says that this passes on to each owner of this unit. So they essentially assumed liability and then transferred that liability, which normally, under the bylaws, one would expect to be with the condominium association.
Counsel, first of all, the facts here are really tragic. I mean, like sad. I mean, honestly, like they're horrible. What happened? But as someone who has owned multiple old homes and done projects, and we have done renovations, and we have uncovered stuff that someone did maybe the last owner or 2 or 3 or 4 owners ago that wasn't up to code, and we had to fix it. So this is a very common problem with older buildings. It seems what you're advocating seems to be saying that any time a sale happens, that the seller is responsible for all of that history. Is that accurate?
Well, that's where I think this more narrow interpretation comes into play, because in this case, I mean, this court could hold, in accordance with the other argument that we outlined in our briefing, both before this court and the Court of Appeals, that the encumbrance was essentially stemming from these condominium bylaws and the modification of those bylaws as to this specific unit. That is, when you purchase a condominium unit, the bylaws say the condominium association will repair common elements. The walls between the 2 adjoining units are common elements, and the association would be responsible for the repair of any of that. So normally, if there was a lack of a firewall and that needed to be repaired, the condominium association would take care of it, and that's what you would expect. But in this case, there was, because there was this unknown modification, unknown to my client, but known to the sellers, that responsibility was specifically tied to the unit of the condominium that was sold to my client. So my client was essentially sold this liability for repair that he wouldn't ordinarily have been responsible for. and wouldn't have any way of knowing he would be responsible for it by just reading the bylaws. And so I think that liability that's being passed on is itself an encumbrance, and that has nothing to do with the broader concerns that have been expressed by the amici and the appellants about building code violations. And we did argue that in the Court of Appeals. That's not the basis for the Court of Appeals decision, but I would say that is a more narrow ground on which this court could rule that would not affect the purchase of old buildings and simply the building. It's very unique to these kinds of facts.
Was that claim litigated in the case? I mean, why do you want to litigate it related to the title? Why not litigate that claim on its own? There's something in the bylaws, and your client wasn't told that they had more liability than the bylaws suggested?
Well, that was part of so there were multiple claims litigated. There were fraud claims, and there was the breach of warranty claim. And, yeah, it was litigated, but.
Was it one of the claims that gave rise to the judgment that you got?
Well, so the problem is that the judgment was ultimately very low compared to the actual costs
I get it, you're looking for more money, but we can't wreck the statute on transferring title to make sure your client gets more money in this one case, can we? That wouldn't be very wise. That screws up the whole way that real estate is conveyed and transferred all across Michigan and has for hundreds of years. Be kind of an inversion of our role, I think. I'm just saying, you're saying this, you have a theory, sounds like a good theory, sounds like you probably used that theory already. You tried to run it up the flagpole once, and now you're trying to run it up again. That's not really how things work.
Well, I think that just in general, these various claims have different elements that need to be met, different types of causation that need to be met, and so a fraud claim isn't the same as a breach of warranty claim. So if this is a breach of warranty, it does have the potential to give my client greater damages than a fraud claim, because we don't know why the jury didn't award the full damages for the fraud claim. There may have been a problem with an element of fraud as opposed to a breach of warranty. So if this is an encumbrance, then I would say that my client does have a right to present all of those claims to the jury and not just a couple of them. And I think under the way that the case law has been interpreted in other states, it is an encumbrance, because it's not just a matter of building code violations versus zoning ordinance violations. It's a matter of this assumption of liability that was transferred to.
Has any court ever held that a latent building code violation is an encumbrance?
There are some courts that have.
Can you name any of them?
I don't know if it would specifically be considered a latent building code violation, but there were some, for example, where there had been notices, not a lawsuit filed yet, but we had cited one in our brief where there had been notices of building code violations. I think that was Brunk v. Farrow. And then the property was sold, and the court did hold that that was an encumbrance. And here, we don't have specific notices issued of the violation.
But that court itself distinguished its case from other cases in which the latent violation had not been enforced prior to the conveyance, which is our circumstance here. So it seems to me that case is sort of on the outer limits, and you're asking us to go even further than that case.
Well, I would say that I don't think that the cases are limited solely to once a lawsuit has been filed. I do think in one of the cases there had been some notices issued, and it was short of a lawsuit, but it was still considered an encumbrance. But in this case, I think it's just a bit of a unique situation, because we're not talking specifically about a building code violation. We're talking about the building violation's interaction with the condominium association bylaws and the condominium rules, and the fact that the sellers had signed this assumption of responsibility for the modification and its repair. So I don't think that there's a case that specifically covers that type of situation, because we have this assumption of liability that's not apparent to the buyer, that was taken by the seller, And I think that that is a separate encumbrance from a building code violation. And I guess it's worth noting that this also, we would dispute that it's latent because the defendants were aware that this modification had taken place, and they represented that there hadn't been any of these modifications. So they assumed responsibility for modifications and the repairs of those modifications. Then they passed it off to my client and didn't tell him about it and warranted that there weren't any claims against the property. But this was inevitably going to become a claim against the property. I think that the case law does clearly assert that, at least at this point, if what had happened now happened before the sale, it would be an encumbrance because there's a lien on the property as the result of it. So the question is just, if a seller has reason to know that this lien is going to arise and they just decide to get rid of the property and not tell the buyer about it, is it not an encumbrance simply because it hasn't quite progressed to that stage yet? And we would say that it is.
How's that different than any latent building code violation, which could, in the future, become a lien on the property if there's an enforcement action by the municipality and it's not complied with?
I think the modification of the condominium bylaws with respect to who's responsible for the repair makes it different from other building code violations. Because if I bought a house, I would know that if there's any building defect, I'm gonna have to fix it. It's my house, there's no association that takes care of those things. But when you're buying a condo unit, and the bylaws specifically say, and people who know about condominiums know, the condominium association takes care of fixing the walls. They're a common element. You don't think that that would be your responsibility. And then suddenly you find out that it is because the sellers didn't disclose something to you and took responsibility for it and passed it on to you. And I think that that's a unique situation here that doesn't overlap with any of the other case law, but distinguishes it from just any old building violation.
Thank you, Counsel. I have to say, I agree with Justice Welch. This is a terrible situation.
Yeah.
And I know you both have been trying to guide your clients through and with the city, so I don't mean to make light of it, but we're just focusing on the legal issues at the heart of the case, at the heart of the issue before this court.
Thank you.
Thank you.
Coincidentally, I was going to talk about the law of other jurisdictions, but now I think I'm going to talk about condominiums instead. What I object to in some ways is introducing this whole condominium story. A, it wasn't part of what Your Honors asked that we address in granting, bringing this up here. And B, there's no factual record to look at. I do enough condominium work. It surprises me that they can foreclose on a condominium for anything other than unpaid dues. And this is just, there's no record that helps me address that. And the same thing with the known to the seller stuff. The Court of Appeals in its decision just said, that's not what we're talking about. I mean, so they're trying to bring this up, there's no record that we have to deal with it. The issue before us is what the Court of Appeals did. And they took this warranty of title and sort of veered off to the left and made it a warranty of fitness. And that just shouldn't have happened. Now, I agree, nobody doubts that this was a problem. I mean, but when we allocated risks, sometimes that's what happens. And, when in my practice somebody comes to me and to look at a sale or something, we'll talk about what are you going to do with the property. And if they say they're going to do wholesale modifications, we talk about what's behind the walls maybe. I mean, these are a risk. I hate to see it happen, but it did. And the law says where this comes out. Sometimes all we can do, especially if that's the only case that's left. All of this stuff they were talking about, they were allowed to address at trial, and the jury heard all of it. And the jury came up with the verdict that it did. I don't know that an instruction on a warranty of title would have changed the jury verdict at all. Neither do they. But I do know that if all of a sudden that's looped into the process, that it'll be a sea change. I mean, it's not that the oceans will rise, but the real property people are going to, it'll be a considerable problem for the real property, for the realtors. And we're asking that the decision of the Court of Appeals just be reversed. I think that's what has to happen. Thank you for your attention and time, and now it's the end of the day.
Thank you. The case will be submitted and the court
It's been an
stands-
entertaining day.
And
Thank you
the
very
court is
much.
adjourned.